All right. Call the next case, please.
Brandon Michael Schklar versus State of Tennessee.
Good morning. May it please the court. My name is Bo Yeager of the Nashville Bar. I'm here on behalf of the appellant, Brandon Michael Schklar.
Good morning.
It's an honor to be before you for the first time. I would request 4 minutes for rebuttal. I would like to start by saying that the general provided this court with a brief that did virtually all the heavy lifting that the assistant district attorney failed to do in his original reply to our petition. That answer asserted only a vague objection that the petition did not meet the statutory requirements for 4030-104, instead noting that it believed the petitioner might have not, that the petitioner should have signed a petition verified under oath. While the standard for review here is de novo, we would just note for the record that the state's answer never explicitly moved for dismissal. It instead said that should the court find that the petition was properly submitted, it would request a scheduling order and a hearing on the petition. This runs afoul to Rule 28, which says that the state must admit or deny every allegation contained in the petition. With respect to that, it fails. However, because such a failure does not trigger a granting of Mr. Schklar's petition, we would go ahead and move forward. Addressing the trial court's response to our petition, they heavily cited the uncitable Terry decision. However, we would agree with the court for the purpose of with the state for the purpose of this hearing that the underlying rationale from Terry came from the Maxwell case that is exhaustively cited throughout their brief. TCA 4030-104 is part of the Post-Conviction Proceeding Act, and it holds that an incomplete petition shall be filed by the clerk, and then the petitioner will be offered a chance to complete it in accordance with 106. 104 also says that any petition or amended petition shall be verified, quote, under oath. There is no insistence that it be done so by way of an affidavit. If the legislature wanted to insist that it be done by an affidavit, it would have said so. If it wanted to say that the failure of not including an affidavit would be fatal to the petitioner, it would not have said that in 106, or it would not have said that the clerk could file a petition and then in 106 have it completed.
But the original petition in this case was not verified under oath in any form or fashion, was it?
The trial court did not allow any hearing that summarily dismissed the petition without any.
I understand, but we have the petition in the record. And
yes, Your Honor.
It on its face.
On its face, yes, Your Honor.
It was signed but not verified.
Signed by counsel, not verified.
Not signed by petitioner or verified by petitioner.
Yes, Your Honor.
So what was improper about the trial court's dismissing it at that point?
We would say that the grounds on which it dismissed it claimed that it had no jurisdiction to even hear the petition, and we would say
Because it wasn't verified.
Yes, Your Honor.
By the petitioner.
Correct. And so the trial court is saying that there's a Rule 28 that the Supreme Court, and I'll get into this, the Supreme Court of Tennessee says that you need an affidavit verified by the petitioner affixed to the petition. That is not included in the statute, in the act that I'm talking about right here, and so I'll get to that in just a minute, Your Honor. The aforementioned 4030-106, specifically Section D, is the section the state and trial court most extensively cite, and that is implicated in the Maxwell case that, again, is exhaustively cited throughout this entire proceeding. The state will say that 106 only affords a pro se petitioner 15 days to file a complete petition should the court have determined that an incomplete petition was originally filed, and that's true. However, 106D also explicitly says that only the failure to state a factual basis for the petition triggers an automatic dismissal. It is not, there's nowhere in 106 that it contemplates that the failure to provide an affidavit triggers automatic dismissal. That is not found in any part of the statute. So put another way, 104 does not contemplate that a petition without an affidavit is one that requires dismissal. It only contemplates that a petition does not.
But doesn't 104 set out what is required
It does.
to be in a validly filed petition?
It
and
does.
It does say it shall include all claims.
It does.
And it shall verify under oath that all claims are included. So
It does.
I mean, our record indicates we don't have a petition in this case that complies with 4030-104, and then the statute later says that the trial court can dismiss
Correct.
a post-conviction for various reasons. So
Yes, ma'am.
Are you trying to argue that that portion of the statute says it can only be dismissed, summarily dismissed by the trial court for
I'm trying to say
certain-
that when the statute in 104 says that it has to be verified under oath, that is not the same as saying it must be verified with a written affidavit notarized by the petitioner. And in fact,
what difference does, I'm struggling to understand what difference that makes in this case.
so there are multiple statutes that, or cases that we have cited, Hinton and Sexton come to mind, where a petitioner was offered the chance to orally verify a petition. And so in that chance, they didn't need, because it was filed without an affidavit, they were still given the chance to orally
I
verify.
understand, but I mean, I looked at a lot of those cases, and we're seeing more and more of this come up. And the interesting thing is, I can't find any of the cases that have kind of the same exact fact pattern. And so I think in Hinton or one of those others, the issue was not raised until they were actually at the post-conviction hearing. And at that point, the trial judge said you had to raise that pre-hearing, and because we're already here, I'm going to let him verify under oath. So
Sure.
do you not find that distinguishable from this case?
There are a couple, Maxwell is the case that is the umbrella over virtually all of this,
Sure.
right? And so, so there's a Maxwell analysis that I'll get to in a minute. I think if we're going to distinguish this case from Maxwell, unlike in Maxwell, Mr. Schklar did respond to the state's initial answer, made numerous supplemental filings on his own, and by the time the trial court had entered its order for dismissal, it had the affidavit and had it for almost a month. A week after the state, if you want to say put Mr. Schklar on notice, he filed an affidavit that was complete and would have complied with every reading of the act.
Is that part of our record
It is, Your Honor. That affidavit would be part of the record.
that was filed 1 week after the petition was filed
So the petitioner, Mr. Schklar, filed his original petition on March 7th, 2025.
with the assistance of an attorney?
Correct. On April 21st, 2025, the state responded, said that they thought, in not so many words, that it was a deficient petition. And then a week later, April 28th, Mr. Schklar filed a petition with a affidavit attached.
But that was after the statute had already run.
Correct. If you want to talk about the tolling of statute of limitations. Yes, ma'am, I can get into that.
Yeah.
I'm thinking back now to my trial court days when I did these a lot. And I thought once a petition was filed, the first thing that happened was the trial court issue a callable or non-callable claim order. Did the trial court do that in this case?
It did not, Your Honor.
Okay, so before the trial court issued an order of any type, the state filed a response.
Yes, Your Honor.
And in that response, they raised the fact that it wasn't verified.
Yes, generally. Yes, Your Honor.
And then he filed something verifying.
Yes, sir.
But before that happened, though, the court dismissed it.
The court did not dismiss it. It had the complete affidavit, petition with the affidavit for almost a month before it dismissed it. So to
Okay.
the question of whether it was moot or not, it absolutely was. So continuing. While 106 says that only a pro se petitioner has 15 days to file a complete petition, it also explicitly says that failure to state a factual basis is the only thing that immediately triggers dismissal of the claim, not the failure to verify a factual basis, and there's a difference there. So put another way, 104 does not contemplate filing a petition without an affidavit as one that requires dismissal, only a petition that does not comply with 106. So to do so actually ignores the very next section of the Act, which is 107B2, where upon the entry of a preliminary order, even a represented petitioner is afforded the opportunity to submit a verified or an amended petition. Okay. Finally, the very next section, Section 108, enumerates 6 different bases that the state could assert in a motion to dismiss. None of those are a failure to verify the petition. Okay? So there's no subsection that supports the state's allegation or the trial court's allegation that it does not have the jurisdiction to consider this for lack of a verified affidavit.
But we do have case law interpreting the statute that upholds dismissal for failure to verify.
There is some, yes, ma'am, I'm sure. I probably cited extensively in the state's brief. It was pretty comprehensive. So moving from the Act to Rule 28, which I mentioned earlier, and how the state failed to meet its, do what it was supposed to do with that answer. It's cited by both the trial court and the state, although I believe only in the state's brief. It's not a verbatim recitation of the Act, but it very closely mimics it. And so in Rule 28, Section E, we find the requirement that This is where we find the requirement that the petition include an affidavit signed by the petitioner, okay? It's not in the Act, it's in Rule 28, Section E. Section F mirrors 108 that I just spoke about, and it enumerates 5 different reasons or 5 different bases for the state to move to dismiss the petition. Again, the failure to provide an affidavit is not a basis for dismissal according to either the Act or Rule 28, Section F. So what this means is the Supreme Court has decided that the filing of a verified affidavit is a standalone requirement, okay? It intentionally left it out as a reason for dismissal. Nothing under Rule 28 gave the trial court cause to dismiss the petition. So comparing 104 and 106, going back to the Act, same conclusion. The legislature deliberately omitted from any specific penalty of dismissal the failure to verify with an affidavit. Because Rule 28 and the Act do not specifically provide a penalty for that lack of verification, it supports the conclusion that this requirement is not mandatory or fatal if not initially complied with. Okay?
Doesn't your argument just tell us to completely disregard Maxwell?
I don't think so. I think that I think first I need to say it here so I can say it in 6 months when it goes to the Supreme Court. I think second, I think that Maxwell reads into the statute rules and penalties that are not prescribed, and so I guess that's what I would ask.
So yeah, you are actually asking, and you obviously understand that we have to follow precedent.
I do, absolutely. Yes, ma'am. So the Act does not name, and Rule 28 do not name that lack of verification as grounds for a dismissal, okay, that the state can move under. A failure to verify is not initially found in either the Act or Rule 28. And so because there's no express penalty, what the judiciary had to do is say, we're going to read one into this requirement, right? So in 104, it says this is what an affidavit needs, including a verification under oath as to the allegations contained within, okay? It does not say that not having that verification is grounds for dismissal, and Rule 28 does the exact same thing. So to decide that a petition filed, decide that there's a petition filed without an affidavit is a nullity, requires that same forbidden rewriting of the statute that we've talked about. 4030-102, one of the things the state is going to mention is the statute of limitations, and it's going to say that because the statute of limitations had run before this petition was included, that he is precluded from going forward with this petition, that it's a nullity. That word comes up over and over. And 4130-102, which governs the statute of limitations in this matter, says time is of the essence and then prescribes that there's a 1-year statute of limitations to do so. That means that it's clear the petition only needs to be filed timely. Again, quoting 4030-102, time is of the essence to file a petition for post-conviction relief. This does not contemplate that the filing somehow ends the statute of limitations, that you can't do anything after that. You just have to file a petition, a compliant petition, and then 106.
But to be compliant, doesn't it have to shall verify under oath all the claims?
So,
I mean, it sounds like you're arguing that just any old petition can be filed. It doesn't have to follow any of the rules. And then I do think that our case law makes a distinction between pro se filings and filings by counsel.
correct. So you can't just have any old filing. You need to follow the rules prescribed in 104 and then in the Supreme Court's Rule 28, okay?
Yeah. And 104 says it shall verify under oath that all
Under oath,
claims are
yes,
included.
ma'am. An affidavit is not part of that requirement. The Supreme Court put that in.
Well, what is under oath? I'm not
So-
following you when you're saying a required affidavit. I mean, no petitions that I've seen come with like a separate affidavit. They just are signed by the petitioner and the petitioner's, verification, and it is notarized.
Correct. So I'll look at a case like Hinton, right, or Sexton, where, again, the petition was submitted without an affidavit, okay, timely filed within the 1-year statute of limitations, just like Mr. Schklar's was, without the affidavit, and then they were given a chance to orally verify that at the trial court.
And they were pro se petitions.
Originally, yes, and at least Hinton. Yes, ma'am.
So are you arguing that there's no distinction between a pro se petition and a petition filed by counsel?
So I would say that we might be getting hung up almost on the wrong thing here. So when I read that the Maxwell case says the pro se petitioner has 15 days to file an amended petition, right, that is not afforded to someone provided by counsel. That petition needs to comply with 104 and Supreme Court rules, right? But that petition does not need to include affidavit. It has to state the factual basis for the allegations. If it doesn't state the factual basis for the allegations, that is an enumerated reason to dismiss the case, okay? But failure to verify with an affidavit is not an immediate trigger for automatic dismissal.
So what about the language in Maxwell? It says the legislature did not extend the same correction opportunity to petitioners represented by counsel.
Correct. So imagine a situation where a represented petitioner submits a petition that does not contain factual basis for the allegations, right? He is not given 15 days to correct that. If I'm a pro se petitioner and I submit an affidavit that the court looks at and says there's no factual basis here under 104 that you would need, then he's given 15 days to comply with that.
I think what happens is, going back to Judge Holloway's example, when a pro se petition is filed, or any petition really, then the trial court, the post-conviction court, looks at it and makes a determination whether there's a colorable claim. And if they're pro se, appoints counsel, and then the statute's very clear about the time frame in which counsel has the opportunity to file an amended petition.
Sure.
So, I mean, that's generally how that process rolls out, which seems to be different than what you're arguing.
Could you maybe expand on a question? I'm sorry.
Well, I think what I'm hearing, the difference is this petitioner had a lawyer representing him. So that, in my view, that changes how the post-conviction judge reviews that initial petition, is because he had a lawyer.
And I think that's what Maxwell tells us.
Correct. But again, we're looking at what needs to be in a petition before it can be either go forward or be dismissed. It just has to verify a factual basis for the allegations. The whole
But this one did not.
Schklar's did. The only thing Schklar's was lacking was an affidavit from him signed, which
But it says the petitioner has to verify. So how could he have verified it if he didn't
he could have
sign
done
it?
at an evidentiary hearing, just like Hinton, Sexton, Timberlake.
But it has to be included in the petition.
So
So you're trying to say that anybody, whether they have counsel, any petitioner, whether they have counsel or not, always has the opportunity to come back and later verify.
if the original petition complied with 104 and had a
But
factual
how
basis
could it
for the
comply
allegation.
with 104 if it does not contain the oath
So,
that is required to
At
be
the risk
there?
of answering your question with a question, I would say, I don't know how the Supreme Court has held that later oral verification complied with the requirement that there be verification included in the petition.
But again, those were really distinct circumstances where the issue was not raised until the post-conviction evidentiary hearing had already begun. And I think in that case, the trial court said, or post-conviction court said, you're late. You filed an answer, you didn't raise it, we're here, I'm gonna allow this to happen now. That's a really different circumstance.
In my memory too of at least one of the cases, the state agreed. Sure.
Correct.
Yeah.
Go ahead and let them sign it.
Yeah.
Right here in open court at the evidentiary hearing, we're not gonna complain, right?
Sure.
That's not what we have here.
It's not. It all goes to the grounds for dismissal. And our position would be that failure to include a affidavit is not grounds for dismissal of a petition. It's just a necessary part of verifying that this petition that did contain factual basis, which is all that is required, was true and correct.
Just so I think Judge Ayers touched on this. It sounds like you're making a distinction between a verification, a petition that's been verified by the petitioner, and an affidavit. Are you making some distinction there?
The Supreme Court does in Rule 28, 104 does not.
Okay.
I believe I'm out of time unless y'all have any further questions.
All right, thank you, counsel. General?
Good morning, Your Honors. May it please the Court, Liz Evan on behalf of the state. I first want to note that most of the arguments we've heard today were not in the appellant's brief. They sounded very familiar to me because they are in a case that's going to be heard before another panel of this court next week. And so I did not brief them in this case because they were not raised. However, if the court wants to see the full briefing in the Jeffrey Pascal case, I did address all of those issues. For example, the idea that 106D amendment only applies to the factual basis. I've addressed that. 106F specifically says that it's upon receipt of a petition in proper form. So the fact that it's the idea that this is just about a factual basis, the whole section 106 has to be complied with. the idea that the verification is not explicitly listed as grounds for dismissal in 108, well, our Supreme Court affirmed the dismissal based on the verification in Maxwell, so clearly that is not an exhaustive list. The idea that the statute of limitations only requires a filing and not a fully compliant petition, that's not borne out by the statute either. Maxwell is pretty clear, and because this is purely a question of law here today, Judge Ayers has already pointed out the language in Maxwell where it says a trial court only retains authority, or it is only if the petition is filed by an unrepresented petitioner that a trial court retains any authority to allow the filing of a compliant amended petition, and that's just not what we have in this case. This case is most similar to the Vaughn case, where a represented petitioner filed a deficient petition, the statute of limitations ran, and then it tried to file a verification later. And this court said that original filing was a nullity. And based on the language in Maxwell, it's clear that a court's authority over a case or controversy is its jurisdiction. So there is no other way to interpret authority when it's over a case or controversy. This is not a question of supervisory authority over lower courts or some other kind of authority. It's authority over the case or controversy.
Does the fact that the trial court, post-conviction court, didn't look at the petition and do the order that says, yeah, there's a colorable claim, I'm going to appoint counsel, does that impact our decision here?
Not at all, for two reasons. One, it was not raised below, and there were multiple opportunities for the petitioner in this case to raise that as an issue. So there is no plain error relief on post-conviction. But more importantly, the Rule 28 order does not arise until after preliminary consideration. So the petition has to survive preliminary consideration under 106 to even move to the 107 preliminary order statute. So the trial court was under no obligation to alert the petitioner of his deficiencies in this case. I would also submit that most recently, Judge Ayers knows this, she was on a panel just 2 months ago. This case is almost flipped from that, where the pro se petitioner filed a properly verified petition, and then the amended petition was not properly verified. And the language was very clear that it was a mandatory statutory provision which deprived the court of jurisdiction over that amended petition, which had not been verified. So therefore, this court could only review the properly verified pro se petition. And so, again, this is jurisdictional language. I know there's been some discussion today about Hinton and how it's distinguishable. I would submit that, with all respect to Judge Montgomery, that was wrongfully decided simply because he did not engage in the principle of Maxwell. He distinguished the facts and then did not engage with the principle of Maxwell, that the trial court did not retain authority to allow an amended petition in that case.
I think I was on that panel as well.
With all respect.
I get that's what we do.
Indeed.
We respect each other. Well, but that was the case, wasn't it? With it seemed like the caused me to go along with Judge Montgomery was the state agreed at the hearing that everything's cool. It's all right that he didn't sign his petition, and go ahead and sign it right there while you're on the stand.
Yes, and that is what happened there, but I would submit that the state cannot consent to subject matter jurisdiction.
Okay.
So just because a state, we see this all the time, the state accidentally agrees with something that's not quite legal, and we have to get this sorted out. And that, I think, is what the case is in that situation.
So is there any scenario where a petition filed by counsel that is defective can be saved or cured after
Sure.
the statute?
Absolutely. If they file a new properly verified petition that satisfies one of the due process or statutory tolling provisions, or they file a new petition before the statute of limitations is run.
Well, before you, I wanted to ask this was a question. I note in your brief, and perhaps even in the petitioners, but wasn't there an amended petition filed here?
An amended petition?
Mm-hmm.
Not that I'm aware of. I feel like there are several responses, and Mr. Yeager will probably know this better since he was there. But from what I recall, there were several responses and maybe some affidavits filed by his parents or power of attorney, things like that. But I don't recall an amended petition. But the purpose of the amendment, as this court knows, is so that it can relate back to the time of filing, right? That's the whole discussion that we're having here, is that maybe if we consider this late filed verification as somehow a properly verified petition, even though it's just the verification, it can't relate back to the timing of the earlier petition.
Well, I have in my notes that there was an amended petition filed on April the 14th.
Oh, you're right, Your Honor. It's not in the record. That's why I'm confused on that. They referred to it somehow in a hearing, but I did not see it in the record. So,
Do we have in the record, I guess, what I'll call the third filing that I think was signed by the father?
the
Or
father?
someone.
So
I know there was a power of attorney
Yes, that is in
appointing
the
the
record.
mother, but I don't think the mother was the one who signed
No.
the document. Maybe the petitioner signed
Right.
that one.
So the original filing was verified by the defendant's father, which
That's
is
right.
improper. Or I wouldn't say even verified, just signed by.
Signed.
Then there was some amended petition in there that's not in the record.
Okay.
Then we have a filing of a power of attorney by the petitioner's mother. And then we have finally, 6 weeks after the statute of limitations ran the verification. Does that answer your questions, Your Honor?
Yeah, that helps.
That last one that you mentioned that was filed 6 weeks after the statute of limitations, is that what he's referring to as the affidavit
I
that was
believe
filed?
so, yes.
Okay.
And that is the first time I've heard that argument too, that a verification is somehow not really an affidavit or some such thing. So all of those are brand new arguments, Your Honor. So we would ask you all not to even consider those because plain error is not available on post-conviction. So unless there are any further questions, we'd ask
What
that
are you asking us to do?
asking that you affirm the judgment of the trial court,
Dismissing the petition?
dismissing the petition. Yes, sir.
All right, thank you, General. All right, counsel, rebuttal?
I apologize to your court and to the state. Maxwell Rule 28, 4030, 101, and subsequent sections are all part of the case. And so just an extensive review of those was all that we were trying to provide to the court. To your question, yes, the affidavit that we're talking about was the notarized affidavit signed by the petitioner that would have conformed with the requirements of.
Do you agree that there is an alleged amended petition dated April 14th that's not in the record?
Yes, Your Honor. I'm not.
You agree with that?
I do.
Okay.
I'm not sure why that's not in the record, Your Honor. So I would, in summation, I would say what we are trying to say is that the petitions of the, or the contents of the petition met the statutory requirements. And so that outside of the verification, which in some cases has been oral, in some cases has been submitted by a notarized affidavit, that when it was improper for the court to dismiss it simply because it did not have an affidavit, even though it was timely filed. And the timely filed means that it was filed within the 1-year statute of limitations from 4030-102, and that is the only grounds the court dismissed it on, and that was erroneous. So we would ask that this court remand it back to the trial court to hear the petition, unless there's any further questions.
All right, thank you, counsel.
Thanks, y'all.
All right, thank you. Take this under advisement. Good briefs, good arguments. Ready?
I'm good.
Okay. Call the next case, please.
Jeffrey Lee Potts versus State of Tennessee.
Cheers, Bob.